I have an update on the quote, media dubbed Ohio House of Horrors case. If you are not caught up, head to my playlist on this channel. And the last video I did, there wasn't too much, I guess, new information about their actual case, which is being presented to a grand jury.
On June 30th, Vinton County authorities stepped into a house on Omar Street to serve a misdemeanor warrant for public indecency on Gary Siders Jr. What they found is now etched into Ohio's legal record. But before the mugshots and the headlines, before the phrase, House of Horrors, was ever typed, there was a document filed by a defense attorney that tried to reframe everything you think you know. I'm going to read you the exact words Lynn Siders' lawyer submitted to the court in a motion to lower her bond. Quote, neither the defendant...
In her filing, she actually says, this wasn't even supposed to happen. Authorities showed up on another warrant for my son, Gary Siders Jr., on, a misdemeanor charge. And then, and the way she phrases it, and I'll pull up the filing in a minute, she phrases it like,
her daughter-in-law nor her husband were suspected of criminal conduct. At the home, authorities encountered unsanitary conditions, and the defendant's grandchildren were removed from their parents' care. There is no allegation that the defendant used or had access to a weapon, nor that the defendant committed any acts of violence against any alleged victim. End quote.
Okay. The available facts indicate that the charges pertain to allegations that the defendant, along with her husband, permitted her daughter-in-law, her son, and their children to reside in their home. On the date the charges are alleged to have occurred, authorities were present at the defendant's home only to serve a misdemeanor warrant upon the defendant's son, Gary Siders Jr. Neither the defendant, her daughter-in-law, nor her husband were suspected of criminal conduct. At the home, authorities encountered unsanitary conditions, and the defendant's grandchildren were removed from their parents' care. All 4 adults in the home have been charged with 1 count of endangering children for each of the children in the home. There is no allegation that the defendant used or had access to a weapon, nor that the defendant committed any acts of violence against any alleged victim. And there is no evidence that the defendant participated in any acts of abuse causing serious physical harm to any of the alleged victims. Rather, it is evident the defendant was the only adult in the home who had been providing for all the other adults and all the children residing in her home. The defendant was also tasked, I skipped something. Defendant paid for rent, utilities, and other necessities in the home. Despite her own medical conditions, defendant was also tasked with caring for her husband and his significant medical needs and physical limitations.
Now, hold that sentence in your mind like a piece of evidence in a plastic bag, because that statement is not a denial of what happened inside that house. It is an admission wrapped in legal gauze. Imagine a life raft so overcrowded that it sinks under the weight of all the people it was supposed to save. 16 children, 4 adults, 1 bathroom, and a woman who signed the checks. That is the portrait Lynn Siders' own motion paints, and it is the visual anchor for everything that follows. Before we go deeper into what the documents actually show, make sure you're subscribed to Endless Cryme, because we don't just cover the story, we follow the evidence. The motion to modify bond is a public record. Case number CR 202-266-2008 in Vinton County Common Pleas Court. It runs 10 pages. Its strategy is simple: frame Lynn Siders not as a co-defendant in a mass child endangerment case, but as an indigent grandmother who was just providing a home.
It was alleged that authorities showed up to the Siders Omar Street home on June 30th because Gary Siders had these 4 public indecency charges. Those are misdemeanors, by the way. Those were all stemming from something he did in May of 2026. So that's kind of what the narrative was. Yeah, they showed up for Gary Siders Jr. and then they discovered,
The filing says she paid for rent, utilities, and other necessities in the home, that she was tasked with caring for her husband and his significant medical needs, and that she was the only adult in the home who had been providing for all the other adults and all the children, just providing a home. That phrase echoes through the entire pleading like a mantra. But legal filings are not truth, they are architecture. And the architecture of this one collapses under the weight of its own omissions the moment you check it against the Ohio Revised Code. Endangering children under Section 2919-22 is not just about beatings or starvation. The statute explicitly includes permitting a child to be in an environment where the child's health or safety is at substantial risk. That means unsanitary conditions, if they reach a certain threshold, are not a footnote. They are the crime. So when the defense writes unsanitary conditions, as if it's a minor housekeeping issue, what they're really asking the judge to ignore is a home where, according to investigators, 2 children were so malnourished and neglected they were near death.
If what authorities claimed at the beginning was true with these kids being 2 of them basically close to death, I mean, how do you not know that? I don't have words for that. But again, I also go back to them living in extreme poverty. And if 80% of them are not mentally competent, I'm kind of like,
They're asking the court to believe that a grandmother who says she took care of everyone somehow didn't notice that children couldn't stand, or that the air they breathed was an active threat. And this is where the filing becomes its own worst enemy. To argue for low bond, the defense must convince a judge that Lynn Siders is not a flight risk, that she's rooted, responsible, the family anchor. She's indigent, they say, with no money to flee.
Okay, so this is just talking about how, she's indigent, she has the right to a reasonable bail, talking about the Ohio Constitution. It's a good motion. I mean, this is a good public defender. Let me see. Yeah, so we kind of went through, this was really that was the main thing that I wanted to go over with you guys. It just says that the home was unsanitary at this point. And also they make a point, which is a really good point. They're like, you think she's going to go somewhere? She has no money. They're like, because a lot of the time, when I cover these cases in the Eastern District of New York, and there are these white collar crimes having to do with money laundering or this or that, we're talking about very wealthy people who have access to private jets, et cetera, that could be, they could flee. A flight is an issue.
But look at what they inadvertently confirmed: she controlled the finances. She was the decision maker. She was the one adult in that house with agency. If you accept the motion's own logic, then you must also accept that the person with the most power in that household is the person who oversaw the conditions that nearly killed 2 children. You cannot be the matriarch who holds everything together and simultaneously claim you had no idea the ceiling was caving in. The irony amplifies with every paragraph. Just providing a home. That phrase collides with another piece of the puzzle. We now know that Gary Siders Jr. was the target of a misdemeanor warrant for 4 counts of public indecency, all stemming from an incident in May 2026.
These kids living in deplorable conditions, and it led to this. Well, then I think it was Gary Siders Sr.'s attorney, Adrian Baum, who kind of came out and was like, it was a local interview. And I may have played it on this channel. I can't recall because I've done a lot of videos. But he said, I just don't think that's the case, because that would be crazy for all these cops to show up or this to be such a big deal over, a public indecency misdemeanor. So he kind of was like, that's not why they were there. It was a different.
Legal experts have noted that such charges, when stacked like that, can be adjacent to sexual misconduct patterns. I'm not alleging anything beyond what's in the record, but consider the timeline. Authorities came for him, and while inside, they saw the children. If he had not been caught, if that door had stayed closed, the outside world would still be blind. So here's the question that reframes this entire story as a thriller, not just a political headline. If a public indecency warrant was the only thread that unraveled this, how many more days did those children have before a different warrant arrived? A coroner's report. The motion argues there's no evidence of physical abuse causing serious physical harm. That's legalese for we didn't hit them. But neglect is a slow blade. You can starve a child without raising a hand. You can endanger a child by letting them sleep in filth, by not seeking medical care, by isolating them from the world so thoroughly that the postal code becomes a prison. The Siders' home was not just overcrowded. It was designed to keep outsiders from looking in. Neighbors barely knew the children existed.
It was a few weeks ago, a pastor spoke out who knew the family. They did not want to be named. And upon this pastor speaking out, he had said, and people had kind of chimed in like, yeah, Christina Siders or Lynn Siders.
A local pastor who spoke anonymously weeks ago said Lynn Siders wasn't secretive about having her grandchildren live with her, that some were even seen out and about. And that detail dropped into the timeline is devastating. It tells you there was awareness. It tells you there were choices. It tells you that what looked like a family to some was, to others, a slow-moving catastrophe.
Competency evaluation. That was granted by the judge. They were also asking his lawyers for everything to be sealed. The request to be sealed, which was very strange in my opinion, and also the results citing, privacy issues, HIPAA, etc. So the judge was basically like, yes, it's granted. And look, by the way, it's not like some big feat to get an evaluation like that granted. I mean, if a judge wouldn't grant that and the defendant goes to trial, is found guilty, and clearly doesn't know where they are or what's going on, obviously that's grounds for appeal. And a judge just wants to avoid that if they can. And so he was granted the evaluation, and all of the results in terms of just his mental health, anything relating to psychiatric records, those will be sealed. But the actual request, not sealed. The judge was like, I don't really see the purpose of that. So that's granted. And also, Christina, Lynn Siders, his mother, has also requested through her lawyers a competency evaluation, and that has been granted. So as of right now, Elizabeth Siders is the only member of the family.
Now we fold in the parallel narrative of competency. Gary Siders Jr. has requested and been granted a competency evaluation, with the results sealed under HAPA. Christina Siders, the daughter-in-law, has also been granted one. Only Elizabeth Siders, the other adult woman in the home, has not yet been ordered evaluated. And Gary Siders Sr., Lynn's husband, appears in court footage frail, in a wheelchair, looking as though he himself is a dependent.
To be a lot of the focus of this case, because he seems to be the one that looks to be the most well-fed out of anybody. Elizabeth Siders is very small. I had mentioned in the last video, Gary Siders Sr., when he is seen getting out of the van when he was arrested, and he's kind of not walking, but he's in the wheelchair and he's sort of next to his son, Gary Siders Jr. looks like he hasn't missed a meal in so long, and Gary Siders Sr. looks smaller. Significantly smaller. Again, Elizabeth Siders, she looks so bony. It's just, and I don't mean that in a judgy way. I just mean that I just don't think that this case here is like, oh, they were neglecting the kids to keep more for themselves. I just don't think, you know what I mean? I think when you hear about, you compare it to the Turpin case, the Turpins were eating and eating fast food in front of the kids and starving the kids and torturing them this way. Look, I don't know, or I don't think that was the case for at least Elizabeth.
This is where the moral math gets impossible. If 3 of the 4 adults in that house are so diminished by mental health, by physical decline, by some combination of both, then who is actually minding the store? The motion says Lynn did everything. It says she paid, she managed, she nursed. And yet, she's the one now claiming she's guilty of nothing more than open door hospitality, just providing a home. That phrase lands differently the 3rd time, doesn't it? It's no longer a defense, it's a confession. By insisting that she was the provider, Lynn Siders' own filing draws a target around the only person left with the capacity to change the outcome and who, according to the state, did not. The Ohio Attorney General's office hasn't charged her with living in a crowded house. They charged her with 8 counts of endangering children, 1 for each of the grandchildren in that house. And while the bond motion says there's no allegation she used a weapon, the law doesn't require a weapon. It requires a child in peril and an adult who allowed it. The weapon, in this case, was time. At the end of the filing, the public defender argues that Lynn Siders should be released on her own recognizance or given a bond she can actually afford. And on paper, that's a reasonable argument for many non-violent defendants. But this case is an anomaly because the harm isn't a single act. It's a condition that festered for years. Releasing her back into the same community where she allegedly presided over that condition doesn't solve the question of accountability. It just hides it behind a door again. So now I'm going to direct you to the source document that makes all of this undeniable. Go to the Vinton County Clerk of Court's online records and pull up the motion to modify bond filed on July 27, 2026. For Lynn Siders, case number CR 200678. I've linked it in the description. Read the whole thing. Pay attention to the language that frames her as the sole provider, and then ask yourself this one direct question in the comments. If she was the only one holding the house together, at what point does holding it together become holding them hostage? If you want to see the evidence yourself and be part of a channel that doesn't just repackage headlines but dissects the documents that build them, then like this video, share it with someone who follows true crime, subscribe to Endless Crime, and turn on notifications. Because the grand jury is convening, and when that indictment drops, you'll want to be here, not reading about it secondhand.